Well, good morning. It's 9:03 on Wednesday, March the 16th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio,
Here.
Farmer, Griffey,
Here.
Hardaway, Howell,
Here.
Lamberth,
Curcio.
Moody,
Here.
Russell,
Here.
Sexton.
Here.
Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, any personal orders before we begin today? Seeing none, we'll go to our Sergeant of Arms, Mr. Tyler Muniz, for our weekly words of wisdom.
Good morning, everyone. I'm Mr. Muniz with your words of wisdom. Today they will be coming to you from Benjamin Franklin. The only thing more expensive than education is ignorance. Thank you. Have a great day.
Very good. Thank you. Members, we're going to look through the calendar and take care of a few things before we kick it off this morning. Item number 212860 by Representative Kumar rolled 1 week. Item number 26, House Bill 2830 by Chairman Littleton, off notice.
26.
Item number 52, House Bill 2853 by Representative Kumar is off notice. Item number 57, House Bill 2848 by Leader Camper is off notice. And go back to item number 8, House Bill 2567 by Representative Sparks will be rolled 2 weeks. Brings us back to item number 1, House Bill 1321 by Representative Hardaway.
Motion.
You are recognized, Representative. There's an amendment.
Second.
Amendment code 14344.
That's correct, sir.
Okay, you are properly recognized on the amendment.
Thank you, Mr. Chairman. And House Bill 1321, as amended, would, and we've been through this before, as you know, we actually had testimony that was offered on this. And when I discussed the amendment that made the bill last time in committee, I spoke to the definition of community terrorism, and that language had been omitted from that amendment. This amendment has that community terrorism in it.
Question has been called on the amendment. Any objection? Seeing none, we're voting on adding amendment code, excuse me, 14344 on the House Bill 1321. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. We adopt. We're on
Question on the bill.
House Bill 1321 as amended. Question's been called. Any objection? Seeing none, we're voting on sending House Bill 1321 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, sir.
Yes, sir.
Thank you, committee members.
If you'll take a short trip with me down to item number 20 on our calendar. House Bill 2810 by Representative Hardaway.
Motion. Second.
You are recognized on the bill. Representative, you have 2 amendments we have here. Is you going to use both of these, one of these, or none of these?
Mr. Chairman, we're going to use one of those. We're going to use drafting code 013914, please.
Yes, sir. Do we have a motion and a second on the amendment?
Second.
You are recognized on the amendment.
Thank you, Mr. Chairman. Mr. Chairman, I may have misspoke. Can we go to, no, I did speak correctly. So House Bill 2810, as amended, does two things. It raises the penalty for fraudulent deed filing from a E felony to a D felony in an effort to deter that practice. It also creates an opportunity for the state to have set in place a framework for a fraud alert program. Mr. Chairman, this fraud alert program is in effect right now in Shelby County. Our Shelby County Register of Deeds, Shalandra Ford, is actually present today and willing to offer testimony to the committee on the fraudulent alert program that she has implemented and how it serves the citizens of Shelby County and how it could effectively serve the citizens of the great state of Tennessee. So I would ask if the committee is willing to go out of session to hear from Shelby County Register Shalandra Ford.
Representative, okay. Without objection, we'll go out of session to hear from Ms. Ford. You can use that podium right there if you like. We did not. You can press that red light. If you will, introduce yourself for the record, and you will have 4 minutes for testimony.
Great. Good morning, everyone, and thank you again to State Representative G.A. Hardaway and to also Chairman Clay Dodgett. I am your Shelby County Register of Deeds, Shalandra Y. Ford. I represent Shelby County. I'm here today to speak on the fraudulent property deed filings within Shelby County. As of today, we currently estimate about 7,500 filings of fraudulent deeds have affected Shelby County as a whole. Fraudulent deed filings are on the rise in Shelby County. The victims are faced with legal fees, and they're faced time away from work addressing these issues in court. It is a constant issue with Shelby County. And as your Shelby County Register, I have been working diligently with State Representative Hardaway and our real estate community to try to come up with a resolution for this matter in Shelby County. One in particular, I have initiated a fraud alert program, and it's now offered to Shelby County citizens, and it's free. We don't have a charge for it. And what it is, it's a temporary fix to the issue. What it does is they go onto our website and they register for our program, and the program will alert them if anyone tries to obtain any fraudulent information on their property or place a lien without their knowledge. It'll notify them via email. But again, this is just a temporary fix. I am also proposing right now in Shelby County, it's a Class E felony if charged, if convicted, and that's almost like a misdemeanor, 2 to 3 years imprisonment. And what I am proposing is to add a stiffer penalty, which would be a Class D like in Deborah, Class D felony, and also adding a provision of adding a $5,000 penalty, $5,000 penalty, and even requesting that we be able to ask for identification per the filings of the quitclaim deeds. The most recent issues are the quitclaim deeds within Shelby County, and those instruments we on a day-to-day basis we're filing anywhere from 12 to 1,500 documents per day with Shelby County Registrar's Office. We are we're revenue generated, so we're not funded by the taxpayer dollars. We're funded by the revenue that we generate within our operation. But this is a widespread and it's a very critical concern within Shelby County, and that's why I'm before you today.
Thank you, ma'am, for your for your time and your testimony to be with us. Members, do we have any questions for our guest? We have Representative Griffey.
Thank you, Chairman, and thank you, Ms. Ford, for bringing this to our attention and your efforts to try to stem what's going on, try to prevent what's going on. I assume this is home title theft kind of situations.
That is correct.
Okay. Let me ask you if I can. Is the fraud being committed by having fake notaries, or is it are the notaries being fooled with, because don't they notarize the quitclaim deeds that they file with your office? And how are they specifically, if you can give us any information about generally how they're committing these frauds, so maybe we can address that as well.
It's actually a combination of both. We are having issues with the notaries, the legal notaries. We don't have a database where we can actually go in and check to see if that notary is valid or not. We just, by law, we can't, I guess, police the documents that we're receiving on a day-to-day basis. But as long as they meet the requirements, the legal requirements, we have to file those instruments within our office. But to answer your question, it is a combination of both. Some of the notaries are mom and pops, or they are familiar with these customers. So it's almost both. It's a combination of both.
Well, I want to thank you for your efforts and anything we can do to try to address this, because it's just unconscionable that innocent property owners have to wake up someday and find out somebody's transferred their property. It costs them all this money and headache. And if we need to look at a mandatory minimum jail sentence for folks that get convicted down the road, I'm sure probably this committee and the General Assembly would be happy to look at that issue down the road. Thank you. And I'll probably sign on to this bill, GA.
Thank you. Representative Beck.
Thank you, Mr. Chairman. And Mr. Chairman and committee, I apologize for being a few minutes late this morning. Number one. And number two is thank you, Registrar Ford, for being with us today. This is such an important item. Here in Nashville, title theft has really become because the real estate market is so hot.
Yes.
And we're ending up I do a lot of estate work, and the children will bring in the will for the estate, and it says I leave my house to my 3 children.
Yes.
We go to do a title search, and lo and behold, the neighbor, the caregiver, the friend down the block, all of a sudden has got the house titled over to them. Thus, and getting that house back in, colleagues, from a deed, a quitclaim deed, is quite a chore and quite expensive. So I echo the words of my colleague from Henry County, because this is people's life investment. This is what they're leaving their children. This is very, very important. And I appreciate it because there has really been no teeth before this bill for this crime. And this can be, hundreds of thousands of dollars or more with very little penalty. So I appreciate Representative Hardaway bringing this, and I appreciate you being here today. Thank you.
Thank you.
Thank you, Representative Curcio.
Thank you, Chairman. I'll be brief. I just want to thank you for being here today, and I apologize because Representative Hardaway was going to introduce us before committee, and I was late coming in because of traffic. But thank you. I think it's a very important issue. We've been talking about this offline. I did not realize that this was a big deal, but it clearly is, and I'm glad we've got a system to address it. So thank you.
Thank you, Representative Russell.
Thank you, Mr. Chairman. How many people is your office currently charging under the current statute each year?
I do apologize. The charges are, that information is actually pending per our DA office. Far as the amount of people that have been charged, we don't have the numbers because, again, those matters are considered misdemeanors.
would you have a approximate number of people that you all charge each year, like 10, 100, or 200? Or?
Roughly, it's more than 100 because we're, like I said, again, through the registrar's office, we're processing anywhere on an average from 13 to 1,500 instruments per day. So out of those instruments, you're looking at about 100 or more that's coming in monthly.
Thank you for that. And can you walk us through the process of how you charge people? Do you make a police report, go to the district attorney? How is that brought forth?
Yes, they would have to, again, the registrar's office, we can't get involved with the legal aspect, but we do refer them. Once they call us, they'll usually call us and advise us that their property has been stolen from under them. And as the registrar, I advise them to contact our local DA office or police department to file a report. But again, our hands are tied as elected officials based on the statute in Shelby County. But I do refer them to seek legal counseling and also to contact the authorities.
So has any of them came back and told you that they actually charged an individual or took out a summons or a warrant?
We just had a case that recently, we just had a case recently that went before court and that individual was charged. But again, those penalties are very, the penalties are very low. I mean, you're looking at anywhere from an average of 2 to 3 years if caught, or if it's convicted. They're looking at only 2 to 3 years, and that's why we have a widespread, because the penalties are not stiffened enough. If you got a criminal that knows, hey, I can get off in 2 to 3 years, they're going to continue. They have been continuing to do this crime in Shelby County, and that's why I'm proposing to stiffer those penalties if possible.
Thank you.
Thank you, Representative Moody. Representative Moody.
Someone was singing the amen chorus in my ears. But anyway, thank you, Ms. Ford. And I noticed when I'm in the car and the radio's on, there's an advertisement. And they're advertising that, I'm sure for a small fee, that they will help you and alert you if this happens to you. So in the back of my mind, you're saying this, and I'm going, yes, I've heard this. But I'd want to commend you because as an elected official, you are a great picture of what government working for the people is.
Thank you.
And not having to pay somebody to do something that your office is willing to step up and recognize. So I want to thank you. And we do need to make a stiffer penalty. But thank you for coming up and thank you for your work.
Thank you.
Thank you. Leader Lamberth.
Thank you, Mr. Chairman. I just want to again thank you for coming here today, and I apologize to Representative Hardaway, who's fighting valiantly for this effort. He had also asked that I meet with you briefly beforehand, and just had several meetings before the committee meeting started today. So I apologize we didn't have an opportunity to meet, but thank you for being here today and highlighting what is an issue that's been out there for several years. My friend from Davidson County mentioned these are very difficult to unwind once someone does this. I will say that I hope you're having a conversation with your district attorney. General Wyrick does a fantastic job for you all. But I hope it's a conversation statewide with all DAs that there are multiple different crimes that can be prosecuted under this. If you've filed a fraudulent lien, if you've filed fraudulent documents with your office, you've committed multiple forgeries, you've committed theft potentially. There are multiple crimes, and I hope they're loading it up with every single crime that they can possibly come up with that these folks have committed. It's pretty nasty stuff that they're doing. So thank you for your leadership on this, and Representative Hardaway, sorry I wasn't able to meet with her before committee.
And I'm sorry, I do have a letter from our state district attorney, Amy Wyrick, in support of my effort. This is a letter from her.
Thank you. Any other questions for our guest? Seeing none, thank you so much for being here with us today and for your testimony and for your work.
Thank you.
Yes, ma'am. We will go back into session. We are on the amendment still. We are on the amendment. Question's been called. Any objections? Seeing none, we're voting now on sending or attaching Amendment 13914 on the House Bill 2810. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're on House Bill 2810 as amended. Question has been called. Any objection? Seeing none, we're voting on sending House Bill 2810 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move to full criminal. Thank you very much.
Thank you, Mr. Chairman. Thank you, committee members, and thank you, Register Ford.
Absolutely. House Bill, item number 2, House Bill 2578.
Thank you, Mr. Chairman. I like how you pointed at me. Well, if I'm going to ask if we could roll this 1 week, because I had an untimely filed amendment, and I think they just want to double check to make sure that it doesn't impact the fiscal note.
Wonderful. Okay.
Mr. Chairman, how many times has this been heard in committee thus far? Is this the first time it's been up? Or?
This first time.
Okay.
Yes, sir, I believe so. So without objection, we'll roll 1 week. Thank you. I'm going to hand this gavel off. I've got to present a bill in another committee. Okay. I'll be back.
All right, members, that brings us to item number 3, House Bill 2252, which is rolled 10 spaces. Oh. I will reconsider our actions, and you are no longer rolled 10 spaces.
Thank you. Thank you, Mr. Chair. Ooh-wee.
That brings us to item number 3, House Bill 2252. You have a motion and a second.
Yes, sir.
We have already, just to remind the committee the posture we're in, we have already adopted amendment coded 13913, I believe. Is that correct? So we are on your bill as amended.
Yes, sir. It's pretty straightforward. Back in 2015, we passed the Neighborhood Protection Act that said if a person is convicted 3 times of certain crimes, such as murder, criminal gang activity, prostitution, and I'm trying to think of some of the other crimes, pretty heinous crimes, that neighborhood association could then, or watch group could petition the judge to have that person have an injunction against that person coming into that community. And all this does is adds criminal aggravated, I'm sorry, let me make sure I say this right. Hold on, wrong bill, sorry, y'all. It adds aggravated criminal littering, basically dumping, to that list of crimes that a person be convicted of 3 times before that association or watch group can petition a judge for an injunction.
Members, you've heard the explanation of the bill as amended. Do we have any questions? Seeing none, all those in favor of sending House Bill 2252 to criminal full, please signify by saying aye. Aye. Those opposed? Sir, you had to criminal full.
Thank you, Mr. Chair, and thank you for recognizing. Mr. Chair, do you mind personal privilege real quick?
You're recognized for a personal order?
Thank you, sir. I know that Davidson County, they brought their Register of Deeds up to the floor and bragged on her, Karen Johnson, which I brag on her too. But we have our own that I brag on also. Mr. Landry Ford and her team, they do an awesome, awesome, awesome job. And I want to thank her publicly. Thank you. Thank you. Thank you, Mr. Chair, and thank you, committee.
Yes, sir.
You can go ahead and rule me out of order. I hadn't.
Right. Yeah, out of order.
Leader Lambert hadn't done it this year, so I need to be ruled out of order if you don't mind.
Out of order.
Thank you.
Yes, very good. Thank you. Members, that brings us to item number 4, House Bill 2707 by Vice Chairman Darby. I do see him in the room. Motion. Sir, you have a motion and a second. You are recognized on House Bill 2707, sir.
Thank you, Mr. Chairman and committee. This House bill was brought to me by a constituent, and this is definitely not in my wheelhouse in front of judicial. I feel like I'm 17 again. But this bill increases the penalty for using a deadly weapon or inflicting serious bodily injury on an officer. It takes this from a C felony to a B felony and increases the sentence range from 3 to 15 years to 8 to 30 years. And with that, I'll stand for questions.
Vice Chairman Darby, we appreciate that explanation, and we welcome you to the Criminal Justice Committee. You can come back and join us anytime.
Thank you, sir.
Members, do we have any questions for the sponsor? Representative Griffey, you're recognized.
Thank you, Mr. Chairman. Not really a question, but just wanted to express my appreciation for you bringing this bill. I think it's a great idea, and we've floated this around for a number of years, but it's a good bill. So thank you for bringing it.
Thank you, sir. Any other questions for our sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 2707 to criminal full, please signify by saying aye. Those opposed? Sir, you had to criminal full.
Thank you, Mr. Chairman and committee.
Thank
And
you,
if
sir.
I could say something later, I appreciate your help on this. Thank you.
Thank you, sir. That brings us to item number 5, House Bill 2319 by Vice Chairman Hall. Second. Sir, you have a motion and a second.
Thank you, Mr. Chairman and committee. Mr. Chairman, fentanyl trafficking and fentanyl overdoses has become somewhat of an epidemic here in our great state. Due to the extreme nature and the dangers of fentanyl, House Bill 2319 increases the bond to no less than $100,000. The greatest act of love that we can show Tennesseans is by keeping these that traffic fentanyl incarcerated longer. And with that, Mr. Chairman, I renew my motion.
Thank you for the explanation, sir. First on my list, I have Leader Lamberth. Leader Lamberth, you recognized?
Mr. Chairman, I think this is an absolutely great idea. Unfortunately, putting a number in the bond would create a bond schedule, and I don't think constitutionally we can do that. The member has valiantly fought against this type of evil drug dealers out there for his entire time in the House, and I hope he continues that and potentially another chamber. But for purposes of this bill right now, I think we could do a lot of different things here. I think we could add this as some sort of a factor that they look at when looking at determining the bond. But for right now, I just don't think the wording of this is ready. So I would renew my motion that I made last week to send it to summer study. I've talked with Representative Hall about that. He's fighting a good fight here. It's just the wording on this one is not quite ready.
Okay. Thank you, Leader. We have a proper motion, and it is properly seconded. All those in favor of sending House Bill 2319 to summer study, please signify by saying aye.
Aye.
Those opposed? Summer study and special calendar.
Thank you, sir.
Thank you. That brings us to item number 6, House Bill 2009 by Representative Gillespie.
Motion. Second.
Sir, you have a motion and a second. I also see you have an amendment, and I want to make sure I get that code right. It is 14828.
Yes, sir, that is correct.
Okay.
Second.
He moves and motions second that amendment. You're recognized on the amendment, sir.
And thank you, Mr. Chairman. And this amendment makes the bill. So can we go ahead and...
Without objection, we're ready to vote. All those in favor of attaching amendment coded 14828 to House Bill 2009, please signify by saying aye. Those opposed, you adopt. You're recognized, sir.
Thank you, Mr. Chairman. I come before you all again with obviously another crime problem that we're having in the great city of Memphis. We've had, over the last maybe 2.5 years, I can't even count how many shootings on our interstates between people shooting at each other or just, honestly, I don't know why they're doing it, but it's putting innocent lives in danger every day. So what this bill would do, if you are convicted of aggravated assault, and that aggravated assault is committed while discharging a firearm from a vehicle, this would automatically escalate the conviction level up one felony level. And with that, I welcome any questions.
You've heard the explanation of the bill. I have Representative Griffey on my list.
Thank you, Mr. Chairman. Thank you, Representative, for bringing this. So my question is, if someone commits an offense and fires a firearm out of their vehicle on the interstate, they're going to be punished as a range, say if they were range 1, they're going to be punished as a range 2 offender as one classification higher, or are we talking from a C to a D?
Representative Gillespie, you're recognized.
Thank you.
I mean, a C to a B.
Right. It is my understanding it would be the latter, the C to a D, because right now aggravated assault is just it's a C felony offense.
Well, I want to thank
Griffey, you're recognized.
Thank you, Mr. Chairman. My apologies. I want to express my appreciation for you bringing this bill, and it's my suspicion that the reason you see an increase on this is people think they can get away with it, and if they do get caught, they think the repercussions are not going to be that serious for them. And the way to stop that is to show everyone that the state of Tennessee, through law enforcement, is deadly serious about this, and they are going to go to prison, period, for a long time if they do this behavior. It's endangering the lives of innocent people. It's completely unacceptable, and I want to thank you for bringing the bill.
Thank you.
Thank you, Representative Griffey. Any other? Chairman Howell, you recognized.
Thank you, Mr. Chairman. Just curious, a colleague of yours in the Memphis area, I believe last session, carried a bill to allow law enforcement to install cameras for law enforcement purposes on certain high crime areas. Has that had any impact at all on this situation?
Representative Gillespie.
Thank you, Mr. Chairman. It's my understanding it's helping. Fortunately, this body just this week passed another law that would increase our ability to hire police officers. And I think that is part of the problem, that the cameras are great, but we don't have the personnel out there to go after those people. So I think with this, in addition to the residency requirement that we just eliminated, will significantly help.
Thank you, Representative Gillespie. Any other questions for our sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 2009 as amended to criminal full, please signify by saying aye. Aye. Those opposed? Sir, you had to criminal full. Thank you, sir. That brings us to item number 7, House Bill 2424 by Representative Sparks. Representative Sparks, you're recognized.
Thank you. House Bill 2424 is regarding litter. It increased the penalty for mitigated criminal littering offenses from Class C misdemeanor, punishable by a $50 fine, to a Class B misdemeanor, punishable by a $500 fine.
Members, you've heard the explanation of the bill. Any questions for the sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 2424 to criminal full, please signify by saying aye. Aye. Those opposed? Sir, you had to criminal full.
All right.
And that brings us to item number 8. I do have a request to roll that bill 2 weeks. Is that correct?
We are. If I can mention, Chairman, I've got, we're setting up a meeting for Monday. Folks that are interested, I thought TBI's coming over. Public Defenders, DA's conference. I think Leader Lambert and a few
I'm
others.
sorry to stop you there, but we're not allowed to discuss bills that aren't before the committee. So
okay.
But we look forward to working with you on that, and I appreciate
Thank you so
help.
much.
Yes, sir. Thank you. Next up, that brings us to item number 9, House Bill 1248 by Representative Thompson. He's in the room. You're recognized, sir. Sir, you have a motion and a second.
Thank you, Mr. Chairman, committee. The HB 1248 simply makes a change in the code for theft of a firearm. As you know, currently in the grading system, the theft of a firearm valued between $2,500 and less than $10,000 is a Class D felony. This bill adds theft of a firearm from a law enforcement vehicle is a Class D felony, even if valued below $2,500. And with other offenses, this emphasizes that crimes against law enforcement are especially egregious, and I will be happy to answer any questions.
Members, you've heard the explanation. Any questions for the sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 1248 to criminal full, please signify by saying aye. Aye. Those opposed? Sir, you had to criminal full.
Thank you, Chair and Committee.
Yes, sir. Thank you. That brings us to item number 10, House Bill 2034 by Representative Harris, who I do not see in the room. We'll roll that 10 spaces. That brings us to item number 11, also by Representative Harris, who's not in the room, rolled 10 spaces. That brings us to the extension of the Harris calendar, and also not here. We are rolling that 10 spaces. Item number 13, House Bill 2097 by our good friend Leader Lambert. Leader Lambert, you're recognized.
Thank you, Mr. Chairman, and glad to be present when I have bills on the calendar. I hope the other members that may not be here will come join us soon if somebody text them. So I'm trying very hard not to look at Representative Beck. So this is, and I think he's texting one of those members right now. This is an issue that has come up for years now on organized crime in our state, and how do we best form a RICO statute that's similar to what they do in other states on the federal level to really go after those folks that are not an individual that's committing a crime, but a group of folks that have come together to conspire to commit those crimes. And members, that's what this bill does. It creates a RICO statute for the state of Tennessee to go after those higher level criminals that are, again, planning and orchestrating this beyond just the one crime. It usually involves multiple different crimes, multiple different people.
Members, you've heard the explanation from the leader. I do have Representative Beck. You recognize, sir.
Thank you, Mr. Chairman. So what you're saying, Leader, is we don't have a state RICO statute?
Leader,
is that what you're saying?
We do not at this juncture. It's charged usually under conspiracy. It's charged under other issues. I mean, there's ways to kind of get to that, but we don't have one that is extensive.
Very good. Thank you.
Thank you. Any other questions for our sponsor? Seeing none, Leader Lambert, I want to thank you for working on this. It's a very interesting topic. I'm glad you brought it up. It's been interesting to read through this piece of legislation. So all those in favor of sending House Bill 2097 to criminal full, please signify by saying aye.
Aye.
Those opposed, criminal full. That brings, yes, sir. That brings us to item number 14, House Bill 2118, also by Leader Lambert. Leader Lambert, you're recognized. Sir, you have a motion and a second. I also see an amendment coded 14969. Do you wish to move that amendment?
Yes, sir, Mr. Chairman.
He moves the amendment. Do we have a motion? Second. And a second. Sir, you're recognized.
Thank you, Mr. Chairman. And this amendment will make it, last year we passed several criminal justice reform bills that dealt with technical violations, dealt with, how folks are violated while on probation if they were to violate the terms of that probation or parole. This just fixes what I believe was a technical issue where we did not intend for that matrix to extend into misdemeanors. And so this would remedy that. There's also an issue that I don't think we intended last year, and this just comes from when we pass bills, especially larger ones. When they get into implementation, folks will sometimes try to use that language of the legislation in a way that we never intended. One of the things that came up is that if a judge tells someone they cannot have contact with the victim of an offense after that individual's been convicted, then they're to have no contact with that individual. If someone were to be convicted of like a rape, a stalking, a domestic assault, an aggravated assault, anything, and there's a no contact order, that's not a technical violation. You contact the victim of a crime, that's not a technical violation. That's a violation. That should potentially send you off to prison or jail if you were to do that act. So, Mr. Chairman, that's what this does, and it really genuinely, I think, just fixes two unintended issues. And I will say on the misdemeanor issue, I don't think that we allowed for that to extend to misdemeanors in the language we passed. But there's folks out there making that argument. So this just clarifies it. We never intended that. We never did it. And this makes sure that it's clear that matrix does not extend to misdemeanors.
Thank you, Leader, for the explanation, and I want to echo that. Of course, I worked hard on those two bills that we passed last year, and it was my understanding that was not intended to apply to misdemeanors, and I believe we may have had testimony in this committee to that effect. So good catch, and appreciate your work on this. Any other questions? Seeing none, we're ready to vote. All those in favor of sending House Bill 2, we need to vote on the amendment. So we're now voting on amendment coded 14969, attaching it to House Bill 2118. All those in favor say aye.
Aye.
Those opposed? You adopt. We're on the bill as amended. The amendment made the bill. Any further questions? Seeing none, we're now voting. All those in favor of sending House Bill 2118 to criminal full, please signify by saying aye.
Aye.
Those opposed? Sir, you head to criminal full.
Thank you, Mr. Chairman.
And I will now pass the gavel to Leader Lamberth while I present my next bill.
All right, members, it's been a little while since I've swung the gavel, so I'm going to get back in the swing of things here. We're on item number 15, House Bill 2306. Do I hear a motion? Second? There's a motion and a second. And, Mr. Chairman, if you please describe the bill.
Thank you, Mr. Chairman. And members, this bill is very personal to me. It's dealing with a case that happened in Dixon County, actually to a young man, a child who was a student of my wife's. And unfortunately, he was murdered, and he was murdered by his parents. And so House Bill 2306 is entitled the Joe Clyde Daniels Act. And what we are looking to do here is currently in Tennessee, a life sentence carries with it a 51-year parole eligibility. There's life without the possibility of parole. And that life sentence carries with it the potential for parole eligibility at 51 years. What this bill would say is that if you refuse to give up the remains or if you obstruct justice in that way, then the parole board may take that into consideration should you come up for parole. We believe that this passes constitutional muster because parole is a privilege and not a right, so it is something that the parole board considers. It's not something that you're guaranteed. And so we feel that this is something that we can do, as unfortunately that young man's father has refused, even to this day, to give up the location of his body. And with that, sir, I would seek passage.
All right, members, you've heard the description of the bill, and there's a sign-on sheet going around, members, if you would like to sign on to this bill. And, Mr. Chairman, I appreciate you fighting for your community. You've fought hard on this issue, and it is just a horrendous tragedy that your community has gone through on this. So thank you for trying to at least give some measure of relief on what is a horrible circumstance. Any questions? Seeing none, will be voting on sending House Bill 2306 to Criminal Full Committee. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. Sir, you go to Criminal Full. If we can, while I have the gavel, and again, you know, while we have a member that is willing to present their bills and in committee, we have item number, I think it's 44, should be the next one on the calendar. It's item number, it's House Bill 2367. Members, if you can take just a moment and turn to that. And is there a motion? Is there a second? Second. A motion and a second. Mr. Chairman, if you're prepared, if we can go forward on item number 44.
Thank you, Mr. Leader. Yes, sir, I am prepared, and I appreciate you jumping ahead to grab that one. This bill actually comes to me from the Tennessee Sheriff's Association, and it would require that association to establish by July 1st, 2023, a criminal proceedings notification system for the purpose of providing timely information about each stage of the criminal process to interested parties. It requires that information in the system be available 24 hours per day over the telephone, internet, or phone, and allow any interested party who registered with the TSA to be automatically notified at least 24 hours before any hearing in the matter for which the person registered, including but not limited to bail hearings, pretrial hearings, trial, and sentencing. The notice must include information on what type of hearing will occur and the date, time, and location for the hearing, and no more than 24 hours after a hearing was conducted in the matter for which the person registered. The notice must include information on whether the hearing occurred as scheduled, and if so, a brief summary of the outcome of the hearing. This short titled is a victim notification bill. We want victims to know what the status of their case is, so that they can keep an eye on those things. And I apologize. I may have
Mr. Chairman, there is an amendment on the bill.
Yeah, I apologize.
No, look, you were given a fantastic description there, and I want to thank Chairman Doggett for coming back in. Just take it easy over there, buddy. We'll get back to you in a few minutes. Thank you, Chairman. We're on amendment number 015147. Is there a motion on the amendment? There is. Is there a second? There's a motion and a second on the amendment. Mr. Chairman, if you can, just tell us what the amendment does.
Yes, sir. The amendment makes the bill in the rather lengthy description that I gave, and I appreciate your patience, does describe the amendment.
Outstanding. Questions been called on the amendment. All in favor of adding amendment code 015147 on to House Bill 2367 signify by saying aye.
Aye.
All opposed, nay. The ayes have it. Amendments on the bill. Any questions on the bill? Seeing none, will be voting on sending House Bill 2367 on to criminal full. All in favor signify by saying aye.
Aye.
All opposed, nay. The ayes have it. All right, you're headed over to criminal full.
Thank you, Mr. Leader.
Mr. Chairman, I see Chairman Doggett making his way back down toward his seat with his gavel and his committee, and I think our fun's over, and I now have to relinquish the gavel back to the chairman. Mr. Chairman, if I may. Thank you, Mr. Chairman. I think we were about to take up item number 58 by Chairman Curcio, which is 1696. That was the next one that I had recommended we take up, but that's entirely up to you, Mr. Chairman.
I will allow your recommendation at this time. Be careful not to request any more, though. And thank you for not breaking my gavel. Item number 58, House Bill 1696 by Chairman Curcio. You are recognized.
Thank you, Mr. Chairman and committee, and I have an amendment I wish to move. It is coded 13. No, I'm sorry, I do not have an amendment.
Okay.
I want to make sure that we're on House Bill 1696. Okay, there's no amendment.
That is correct.
Excellent.
You're recognized on the bill.
Thank you. House Bill 1696 enhances the penalty for the offense of aggravated burglary from a Class C felony to a Class B felony if the burglary is of an occupied habitation. It increases the penalty for especially aggravated burglary from a Class B felony to a Class A felony if the burglary is of a habitation. This was born out of a multi-year conversation, actually, that Leader Lamberth and I have had about the especially violent aspect to breaking in and burglarizing someone's home when they are present, when you know they are there. We don't advocate anyone breaking into anyone's home, but when someone does that in the middle of the day when there are no cars in the driveway, that is it's deplorable, but it is not nearly as violent as coming in the middle of the night when there are cars in the driveway. I know my own father told me when I moved out on my own, he said, son, if somebody comes in the door while they know you're there, they're coming there to kill you. And you better be ready. And so under this bill, we seek to acknowledge that especially violent act. And it also, in addition to being kind of a multi-year conversation, was brought to light, unfortunately, through the murder of a young man at Rhodes College just this past year. And I've met with members of his family, and they've also been to the Criminal Justice Committee to testify a couple of weeks ago. Many of you had the opportunity to hear from them at that time. And so, again, kind of like a previous item I had on this calendar, this is what we can do. And I think this sends a message, a very strong message to those who would try to commit these heinous acts. So with that, I seek passage.
Thank you very much. Questions from the sponsor, Leader Lamberth.
Thank you, Mr. Chairman. And Mr. Chairman, and I've read through this and just wanted to kind of get it on the record. There is nothing in here that changes any definition of burglary. There is nothing that reduces any penalty of burglary. What we're doing here is we are seeking to increase burglary when again, just as you said, those aggravating factors exist that differentiate breaking into someone's home with intent to commit a theft, felony, or assault when no one's there versus when someone is there. It's just a much more dangerous situation, and that's why we're doing that. Is that accurate?
Thank you, Mr. Chairman. Yes, that is exactly right. So that's what we seek to do. And you can see the increased state expenditures there, $5.2 million. And that's obviously a big hill to climb. But as we've talked about in this committee many times, oftentimes in the Criminal Justice Committee, if you don't have a big fiscal note, you may not be accomplishing much. So we seek to get this funded.
Thank you, Mr. Chairman. If that cost saves even one life, it's worth every penny. And so, I mean, I realize we see some of these large fiscal notes, but I agree with you. I mean, it shows that this is obviously happening on a regular basis, and it's being charged as just a simple burglary right now. So thank you for bringing the bill. It is an extremely good bill that needs to pass. Thank you.
Thank you, sir.
Any other questions for the sponsor, Representative Hardaway?
Thank you, Mr. Chairman, and thank you to the sponsor. I agree with your daddy. If they coming in and they know you're there or likely to be there, you need to greet them with that pump. All right. I'm 100% on board with your bill.
Thank you.
Thank you. We do have someone signed up for testimony on this. Pamela Moses. Is Pamela Moses here? Seeing none. Okay. All right. Any objection to the question? Seeing none, we're voting on House Bill 1696. All those in favor say aye. Aye. Those opposed, the ayes prevail. Move on to full criminal.
Thank you, Chairman and Committee.
We are back on item number 16, House Bill 2147 by the Chair Lady Moody.
Motion. Second.
You're recognized. There are two amendments. Do you want one, both, or none of the above?
I believe we're taking 015650.
Okay. Yes, ma'am.
Thank you.
15650. Need a. All right. You're recognized on the amendment.
All right. Members, this bill came from, it's dealing with our human trafficking laws. So this is, I guess the best description would be a cleanup bill, but it's also, what we're trying to do, there's a Shared Hope International, and they grade the states by how strong their human trafficking laws are. And I'm proud to say that most of the years, Tennessee's been number one with the strongest. And as they reevaluated, of course, as human trafficking evolves, the evil that it is, they have more. They've changed some of the ways, what they're looking for in strength in laws. So this bill is kind of that cleanup to help get us back into our number one position that we're used to. So it covers many things I don't know if anyone has a specific question or if you want me to read some of the summaries. It is lengthy, but this is what it came from, and this is from the governor's office, and I'm grateful for their solid interest in helping us claim number one again in fighting human trafficking.
Question is called on the amendment. Now voting on adding Amendment Code 15650 on the House Bill 2147. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We're on House Bill 2147 as amended.
Thank you, members. And I'll just say, too, I have been made aware, with the borders being open south of us, I'm telling you, they're arresting people with young girls in their cars that are coyotes that are coming through Tennessee. It's just, unfortunately, continues to increase the problems that we're having. But I would just like to ask for your passage of this bill, but we'll be happy to answer any specific questions you may have or clarifications you may need on this.
Withdrawn. Thank you. Leader Lamberth.
Thank you, Mr. Chairman. There's one small amendment that came from outside of the normal process, but it is an amendment that I filed on behalf of the District Attorney General's Conference. It's coded 015073. It literally just cleans up an issue in the code that if an officer is posing as a minor and someone is soliciting them and has every intention of pursuing a minor for purposes of human trafficking, then it would not be a defense that that person's not a minor. This happens all the time. This is how they do these stings. Quite frankly, if we don't have something like that in the law, they'll be forced to use actual minors in those circumstances, which is not safe by any stretch of the imagination. So that's all this amendment does, Mr. Chairman. I would tender that for consideration by the committee and make a motion for its acceptance. It was timely filed, Mr. Chairman.
Okay, you received a motion and a second on the amendment.
Question on the amendment?
Question's been called. Any objection? Okay. Voting on adding Amendment Code 15073 on the House Bill 2147. All those in favor say aye.
Aye.
Those opposed? You adopt. We're back on 2147 as amended. Excuse me, time out.
Go.
Sorry.
No.
We need to roll both amendments into one here.
Yes.
So, good. Without objection, we'll roll both amendments into one. Now we're on 2147 as amended. Representative Moody.
Thank you again. And it is something to get to be a part of some of those stings that have happened. I can't help but I don't want to fail to mention Representative Coley and his leading the way on this great work. And it's been an honor to work with him while he was here with us on this. And, he was just, I want to give credit where credit's due. I wouldn't be here without him reaching out and sharing the work. And so it's just something that it's just hard to explain when you see. And I've gotten to see where they got one. And it was they were posing as underage girls, and to think, anyway, if you ever pay attention to when they post in the paper after they've had one, who they've arrested, it's every age, it's every profession. I know one thing that shocked me was I thought it would be, at night, late at night, dark. We would go to the stings in the afternoon because it's like on their way home from work or whatever. So there's a lot of it's just an incredible work that our TBI does, all our law enforcement, the nonprofits that we have in the state do tireless work on shoestring budgets, and again, I'm just happy to be able to carry this. and to get us back into that number one position in the country.
Well, thank you so much, and thank you for your work on this. Any questions for the sponsor? Seeing none, we're going to vote on sending House Bill 2147 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. Move to full criminal. Members, let's go to item number 34, House Bill 2135. Motion. By Leader Beck. You have a motion and a second. Representative Beck, you're recognized.
Thank you, Mr. Chairman and committee. House Bill 2135 requires the magistrate to order a defendant arrested for any criminal act as defined in Title 39, Chapter 12, where the alleged victim is a domestic abused victim. An alleged offense includes strangulation or threaten to use firearms in order to wear a GPS device, and if able to pay for the cost associated with the GPS device. And Mr. Chairman, we have a witness who is flown in from across the country who we would like to testify this morning, Mr. Alex Young. If we could go out of session and call him up, I would appreciate it.
Absolutely. Without objection, we'll go out of session. Mr. Young, you can go to the podium, or you could sit at the chair there. If you will introduce yourself, and for the record, you will have 4 minutes for comments and then questions from the committee.
Thank you all very much. My name is Alex Yan, born and raised here in Nashville, Tennessee. And last April, my mother, Deborah Sisko, and my sister, Marie Varsos, were murdered by my brother-in-law. In the weeks prior, my sister was strangulated by my brother-in-law to the point where she eventually passed out. When she awoke, she was held captive with a gun to her head, pleading for her life to be saved. Eventually, she was able to escape. Over the following 5 weeks until their homicide, my sister, my mother, myself, and the rest of our family did everything we could to navigate the very bureaucratic process domestic violence victims face every day here in Tennessee. We lived in a constant state of fear, not knowing where my brother-in-law was or what harm he could do to my sister or our family. After spending what seemed like a grueling hell, closing down all 3 of their affairs in the middle of a global pandemic, 2,000 miles away nonetheless, I set about the process of trying to understand what, if anything, could have been done to save them. I wanted to make sure no family had to endure what we've had to go through. I reached out to a handful of agencies my sister came in contact with, the same agencies we turned to for help to understand what might have happened. Through that process, I put together a timeline to understand what had happened and what could have been done to prevent this tragedy. And that's what brings me before you here today. Although he should have been held for 12 hours following his arrest, my brother-in-law was released early on a $3,000 bond and was unrestrained. He navigated the justice system without friction to do whatever he so pleased and with hardly any penalties. It's far too easy for domestic violence offenders to be released from jail. In addition to having such a low bond, Tennessee law actually requires that magistrates consider GPS monitoring as a condition of release in domestic violence cases. This did not happen with my brother-in-law, and as far as I can tell, GPS monitoring in domestic violence cases has never even been implemented in Davidson County. The morning of my mother and sister's murder, my brother-in-law waited outside of my mother's home for 45 minutes. In a rental car, he had duct tape, gasoline, battery acid, zip ties, a taser gun, in addition to his firearms. He stalked my sister for weeks leading up to the moment to understand her schedule. Had he had GPS tracking device on him, and had my sister been notified of his presence, I truly believe that she and my mother would be alive today. I ask and plead with you to help address these loopholes by supporting two bills today, actually. House Bill 2135 and House Bill 2020. I realize that this will not bring my mother and sister back, but I hope that it will help save others. And I thank you all for your time to letting me speak today. Thank you.
Thank you so much for being here with us and sharing your testimony. Leader Lamberth.
Alex, thank you for being here today. I know I was one of those phone calls you made now months ago, and I know Kathy Walsh has been helping you through the system here. She's been fighting these fights for decades here in the legislature, and it sounds hollow because it pales in comparison to what you've gone through, man, but I'm sorry. And I know when we met in my office and when we spoke on the phone several times, I've told you that this matters, what you're doing today, and it does, okay? Coming here in the memory of your sister and your mother and sharing with us and sharing with all of us and anybody that's watching right now the hell that y'all have gone through, it puts a face on the words on the page that we're considering. So I want to thank you for coming down here. Thank you for coming all this way. And I am sorry for what you've had to go through. And I hope what we can do is, like we talked about in the office, I hope we can pass something that makes sure fewer families and hopefully no families would go through what y'all have had to go through. And so thank you for championing these issues, and thank you for coming before us today.
Appreciate that.
Thank you. Representative Beck.
Alex, thank you so much for being here today. It's such a brave thing to do, and we appreciate it. One thing I wanted to expound upon that we talked about in my office was how your brother-in-law plotted this out. And one thing that you told me is how he got that rental car. And why was the reason that he got the rental car? I think that just shows his and the things that he had with him show how plotting and evil of a deed that he was going to commit.
No, thank you. You know, my sister and my brother-in-law were in the process of going through a divorce, and my sister was living with my mother at the time. So my brother-in-law didn't understand my sister's schedule. She was a pharmacist who was working various different hours at the time. And he wanted the element of surprise. He wanted to make sure that my sister had no idea that he was going to try and kidnap her and do harm on her. Ultimately, he was not successful at that. He broke in. My sister was heading to get in her car to head to work, and my sister noticed him and very casually turned around and walked back into the front of the house. And she ran upstairs and got her firearm and armed herself. And he broke in through the back door with a shotgun. And my mother and sister ran out the front door. And unfortunately, my sister was just overpowered. And I think that, you know, had my sister known that he was waiting outside, you know, for 45 minutes, she could have armed herself faster. They could have called authorities faster. He probably wouldn't have thought to go through all these different mechanics. I mean, listen, at the end of the day, he was going to try and do whatever he could to kill her. But the intent was there, and I think that with technology today, if you lose your keys, you can find your keys.
Mm-hmm.
If you misplace your child, you can find your child.
Mm-hmm.
And it should be easy for someone to be able to track a domestic violence offender and protect them from a victim.
Thank you again. Thank you.
Representative Griffey.
Thank you, Chairman. Thank you for coming to us, Mr. Yon, and sharing your story. I just want to throw out, maybe this committee ought to consider, maybe next legislative session, that we give the courts access to, so someone's cellular phone can be tracked, because that's one of the best ways to find out what somebody's doing. If they leave their phone, they're kind of dead in the water on stuff. So that might be something to think about down the road. So thank you. And I'm sorry for your loss.
Leader Lamberth.
Mr. Chairman, while we're still out of session here on that point, and we're not in discussion, but I believe that some of the technology that you're pushing as part of this bill is that it would involve GPS monitoring, but through cell phones, it's much less expensive. Is that true?
Yes, it would be so easy as the offender having a bracelet, much like a watch like I have, and then the victim would have an app on their mobile phone so that in real time, a individual who approached a victim, that victim would be notified as well as law enforcement would be notified right then and there. In previous, if you think about GPS monitoring with addresses and coming there, technology's changed so much where that can happen. And it is amazing what the technology can do. What's more surprising is that this is something that you can already implement in various counties, but is not being done. So,
Thank you, Representative Hardaway.
Thank you, Chairman. And as most of the committee members know, this is near and dear to my heart, and my heart bleeds with you, sir, on your loss. And this is something that I've been working on with Judge Carter and Lita Lambert since I first got here. The technology is there. It can tell you where you are in a room. It certainly can track where you are in proximity to a home or to a street. So I applaud you on having the courage to come and share your story and to keep pushing for the policies and the statutes that will prevent this from happening again as much as we possibly can with the legislation. But every time that we have an individual that is released on bond and the charges are similar or specifically domestic violence or some type of sexual offense or stalking, they ought to be GPSed. We should not have a justice system where the alleged victim has to self-jail and isolate. When we have the ability to track and manage the offender. We had an instance in Davidson County where there was a domestic violence incident. The perpetrator waited after he knew that law enforcement was on its way. He waited and waylaid and killed a sheriff's deputy. If he had been GPS, then law enforcement would have known that he was there. They would have known before he went that way. But I'm 100% on board with you, and I feel the spirit of Representative Mike Carter with us, because this technology is something that he researched extensly, and that's really the basis of a lot of my knowledge on it. So I thank you for being here. I'm 110% on board. And there's some other things, as my colleagues know, that we need to do. But the question is whether we have the will to do it quickly and save lives. So I'm with you. And Mr. Chairman, I'd urge the committee to give this due consideration and move this along. Thank you.
Thank you, Representative. Any other questions for our guest? Seeing none, thank you for your time being here with us. We'll go back into session. We're back on House Bill 2135. Question has been called. Would you withdraw just for a moment? Yes, withdraw. Thank you.
I just wanted to address my colleagues from the top row's concern. And this bill does say to carry or wear a GPS device. So as technology increases, that will allow them to carry a GPS device. So I think that was an excellent point, and we thought about that when we were putting the bill together. So hopefully the technology will be that we can do that in the future and make it cheaper. I understand what your concerns, and I thank you. And with that, Mr. Chairman, move approval.
Thank you very much. Previous question is called. Any objection? Seeing none, we're voting to send House Bill 2135 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. Move on to full criminal. I'm going to pass the gavel down to Leader Lamberth so we can take up One of mine.
Members, we are on item number 51, House Bill 2020. And I understand the witness needs to leave and go over to the House Senate Judiciary Committee, but it's on the same set of bills that this witness has testified on already. So if y'all need to go ahead and leave, go ahead. I did take the liberty of texting your Senate sponsor, Senator Reeves, and let him know y'all might be a few minutes late. So thank you for your testimony, sir. Members, again, we're on House Bill 2020 by Chairman Doggett. There's a motion. There's a second. Chairman, if you can tell us briefly what the bill does, please.
Thank you very much. This bill requires that when making a decision concerning the amount of bail required for the release of a defendant arrested for domestic violence in which the victim of the offense, in which the victim was strangled or there was an attempt to strangle or made threats against the victim's life, the bail should be set no less than twice what is customarily set for the offense charged.
Mr. Chairman, we do have a witness beyond Mr. Young who's already testified, but Ms. Pamela Moses from Rise Up America Incorporated. I believe she signed up on several bills and has chosen not to join us today, but we do have her as a listed witness. Is she here? Again, Ms. Pamela Moses. Are you Ms. Moses? Yes, sir. Okay, we had you down on several bills today. We're on House Bill 2020. Ma'am, do you wish to testify?
Yes.
Oh, hang on just a moment then, members. Without objection, we're going to get out of session. Ms. Moses, if you can approach your podium there, please. Okay. Take a second to collect your thoughts there. It's okay.
And I had so many. Could you read
It's okay, ma'am. We're on House Bill 2020. What would you like to share with us, ma'am?
I need you to brief me on which one that is sponsored by, because I signed up for quite a few.
Yes, ma'am.
Or give me a second to get my notes.
Take a second to get your notes. It's House Bill 2020 by Chairman Doggett. If you would like to take a moment, and then when you begin, you'll have 4 minutes, ma'am. I'm sorry, we do have several other items on the calendar. I know you've signed up for several. Are you sure you want to testify on House Bill 2020, or would you like to take a few, maybe just kind of regroup for the next bill?
Well, if you could just give me 1 second, please. I'm
Yes, ma'am,
sorry.
that's
I
fine.
had trouble parking. There's no...
Ma'am, it's perfectly fine. Take a moment. It's all right. Ma'am, I am extraordinarily sorry, but we do need to go ahead and move on. I've given you a few minutes here. It's House Bill 2020.
You know what? I'll let you go on. I'll just wait for
Thank
the
you, ma'am.
Senate committee.
That's okay. Thank you, ma'am. And I appreciate you being here today, and I apologize, but we do need to.
No problem.
Thank you, ma'am.
It was raining and I was late. I should have been here earlier.
That's okay. We totally understand, ma'am. If we have quite a bit of debate on this bill for some reason and you get ready, just raise your hand. We'll come back to you.
Yes, sir.
Thank you. Members, we're going to go back into session. All right, members, we're back on House Bill 2020. You've heard an explanation of the bill. Is there any debate on the bill? All right, questions being called on the bill. Members will be voting on sending House Bill 2020 by Chairman Doggett on to Criminal Justice Full Committee. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. All right, Chairman Doggett. And Chairman, as I hand the gavel back to you, I do see Representative Rutter is here in the audience today, and I believe she is here on item number 29, which is House Bill 2459. Chairman, it's entirely up to you at this juncture, but I would make a humble request. If you would like to take up Representative Rutter, I'd sure appreciate it.
Well, thank you very much, and I believe I'd given you a warning earlier about the request. However, I had already coordinated with Representative Rutter that she would be next, so.
My humblest apologies, Mr. Chairman. I'm just a big fan
Anyone
of Representative
else, I would
Rutter's.
have rolled her 5 spaces, but because she is our state flower, I will take her up. House Bill 2459 by Representative Rutter. You are recognized.
Thank you, Mr. Chairman and committee. Well, I want to open this morning and tell you all that this is one of my This is an honor to bring this bill before you this morning. It's one of my favorite things to get to do because a constituent reached out to me with a problem, and I do hope that this piece of legislation will be the solution to her problem. What happened to my constituent? She called me this summer and shared with me what happened to her 14-year-old son. He was in a local high school and was videoed while he was using the restroom. And then the young person that did this put it out on social media via Snapchat. And so you can imagine what happened a few days later. All of the giggles in the hallways, pointing at the young boy, young man, should I say. Eventually, it was found out what had happened. She sought an apology from the parents and didn't get much satisfaction there, so she went to our schools. And she was told that they would suspend the young man, which they did, but it was the last 7 days of school. So that, in her opinion, wasn't much of a punishment for what had happened to her son and the embarrassment that he had suffered. So she went to her local DA. She went to our DA. And because this young man in current law did not use the photography or the video for sexual gratification, the DA's hands were tied. So this legislation that I'm bringing you today simply amends our current photography law by adding this language. That if a person is photographed without their consent, and in the case of a minor, without the consent of their parent or legal guardian, and that photograph is of an unclothed, intimate area, and the individual would be would find it offensive or embarrassing, and it was taken for the purpose of offending, intimidating, embarrassing, ridiculing, or harassing the victim. And then it was disseminated by the defendant, and the defendant threatened to disseminate the photography, or the defendant permitted the dissemination of the photography to another person. This bill would add to the current law that said this offense is a Class B misdemeanor for the first violation and a Class A for the second or subsequent violations. This behavior is becoming more and more of a problem in our society, and the courts need a recourse in which to deal with this growing problem. And with that, I'll take any questions.
Thank you for the explanation. Members, any questions for our sponsor? Question has been called. Any objection? Representative Hardaway, are you objecting?
Just one question if the motion.
Okay, it's withdrawn.
Thank you. And thank you, sponsor, for the bill. When you described it, you said an unclothed area and I'm trying to figure out in the language of the bill itself, will it speak more to being revealed? Because sometimes it can be clothed and still visible.
This is the language in the bill is unclothed area, and it does go into what that would be.
Okay. With your permission, between now and full, I'd like to explore that further so we don't have someone exploiting a gap or using gimmicks to get around it. All right. Thank you, Mr. Chairman. Thank you, sponsor.
Yes, sir. Thank you. Any other questions? Seeing none. Question has been called. We're now voting on sending House Bill 2459 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman and committee.
Let's go to item number 48, House Bill 2554 by Vice Chair, or excuse me, 2524. Item number 48, House Bill 2524 by Vice Chairman Sexton. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman.
Sorry.
What House Bill 2524 does is it carries forward a little bit, or it builds upon the governor's constitutional carry from last year. It's called the Second Amendment Simplification Act. And under current TCA 3917-1307, a person commits an offense who carries with the intent to go armed a firearm with a firearm or a club. This means that anyone who leaves their own property with a firearm or a club automatically commits an offense. Possessing any kind of carry permit is not an exception to this offense. It is only a defense. This means that anyone in Tennessee who carries a firearm can be arrested and processed for committing a crime. Once before the judge, they can show their permit as a defense. However, this person still has been detained and possibly incurred legal expenses. If it pleases the committee, I'd like to ask that we go out of session and call up Richard Archie to comment on this.
Thank you. We do have a few names here that for testimony. So, without objection, we will go out of session. First on my list is Richard Archie. You will have 4 minutes. Introduce yourself. You'll have 4 minutes for comments.
My name is Richard Archie, Chairman of the Committee. Thank you all for allowing me to comment.
If you will make sure that microphone is on there, please, sir.
It's on. It's red. May not be close enough to me. Okay. I'll lean a little more forward. In 1796, Thomas Jefferson said that the Tennessee Constitution was the least imperfect and most Republican of all the documents he had seen to date. It is the duty per that document of the General Assembly to vote without favor, affection, partiality, or prejudice, and not propose or assent to any bill, vote, or resolution which shall appear injurious to the people, or consent to any act or thing whatever that shall have a tendency to lessen or abridge their rights and privileges, as declared by the Constitution of this state. Article 1, Section 26 says, the citizens of this state have a right to keep and bear arms for their common defense, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. Andrew v. State, a Supreme Court case in 1871, used, by the way, to bolster the Heller decision, said this in its majority opinion. The Tennessee Supreme Court has recognized that the General Assembly has the authority under this section of the Constitution to enact legislation to regulate the wearing and carrying of arms in public. Any such enactment, however, must be guided by and restrained to this end and bear some well-defined relation to the prevention of crime, or else it is unauthorized by this clause of the Constitution. The right to keep arms necessarily involves the right to purchase them, to keep them in a state of efficiency for use and provide ammunition suitable for such arms, and to keep them in repair. And clearly for this purpose, a man would have the right to carry them to and from his home, and the legislature has no right to punish him for it without violating this clause of the Constitution. The Second Amendment of our Union says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The amendments are, in fact, a part of our Constitution. Article 6, Section 2 says, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. In Marbury versus Madison, the Supreme Court of the U.S. held, a law repugnant to the Constitution is void. Any act of Congress repugnant to the Constitution cannot become a law. The Constitution supersedes all other laws, and the individual's rights shall be liberally enforced in favor of him, the clearly intended, express designated beneficiary. In 2010, McDonald v. City of Chicago, the Supreme Court declared the Second Amendment right for individuals to keep and bear arms for self-defense is a fundamental constitutional right under the Due Process Clause of the 14th Amendment, and therefore applies to state and local governments as well as the federal government. It incorporated against the states. In 1821, the General Assembly of Tennessee passed legislation that denied the citizen the right to carry firearms legally, making it a crime to do so. In the recent New York Rifle and Pistol Club v. Bruin case before the Supreme Court last November, the Solicitor General of District of Columbia, Brian Fetcher, in support of the state of New York, held up Tennessee as the poster child for gun control. When he testified, "I'm focusing on laws that either prohibited or required a showing of good cause to carry a concealable weapon like a pistol. Tennessee enacted this law in 1821, and it is on their books today. The permits in Tennessee are either exceptions, exemptions, or defenses against prosecution, but the fact remains that bearing a firearm with the intent to go armed is an offense under 39-17-1307. An offense is a crime. Tennessee Supremacy Clause, which I consider it to be, Article 11, Section 16, says the Declaration of Rights hereto prefixed is declared to be a part of the Constitution of this state and shall never be violated in any cause whatsoever. And to guard against transgression of the high powers we have delegated, we hold that everything in the Declaration of Rights contained is accepted out of the general powers of government and shall forever remain inviolate." I ask you today to vote in favor of this bill. It's time that we took the crime aspect off of what is a God-given right to Tennessee citizens. Thank you.
Thank you very much. Thank you for your time and being with us and your comments. Members, do we have any questions for our guest, Leader Lamberth?
Thank you, Mr. Archer. Good to see you again today. And that was a great recitation of kind of the buildup of the laws that we have on the books. But I wanted to get specifically to this bill. And this has been a bill that I know you and I have talked about several different times. And the concept of it, I support. I want to get into just the meat of it just a little bit here. So, I mean, in essence, at some point decades ago, some legislature long before we got here decided to say, look, it's a crime to carry a firearm for purposes, to go armed. And then they made several exceptions to that. Now, I do disagree a little bit on how it works in practice, and I know I've talked about this, but, several of us practice in the courts throughout this state. You're not prosecuted and then the exception comes in. The exception's built into the statute, and so it makes it where it is not lawful. Or it is not unlawful, excuse me. It makes it where it is lawful to carry in quite a few areas, just like last year with the constitutional carry bill that expanded significantly those areas. And I want to ask a question about that. So a subdivision in this deletes 39-17-13-11. And that's a pretty extensive section. What's the intention in deleting that? And again, not opining whether I agree or disagree, just asking the question on what's the intention of deleting 39-17-13-11.
I think it is exactly what we intended when we wrote the bill, was to clean up the aspect of it being a crime in Tennessee to carry a firearm. And so deleting that, we're trying to go through the code section as time after time we come before these committees with a bill that doesn't necessarily clean up all the code sections, so it gets rolled because it doesn't take out everything that is necessary for us to get that issue done. And so deleting that portion is what we're trying to do, is get everything out to where it's just not a crime. And you and I have talked, again, like you said, about in practicality that it's not a crime. However, it says so in 1307, and that's what we're trying to do, is remove that.
Well, I know that, but in 1311, it actually it provides for quite a few defenses in there,
yes,
and exceptions. I mean, things like carrying a gun or a knife into a gun or knife show, and there's an exception there. And I'm worried about losing that type of defense, because I don't want someone who's going to a gun or knife show. I mean, most of these are gun or knife shows, to somehow or another trip over a statute or even a local municipality rule, which I don't think should prohibit those things either. Are you absolutely certain that somewhere else in your bill you're providing for those defenses? Because I don't want a law-abiding gun owner, and I know you don't want either,
I do not,
or a law-abiding knife owner to lose a defense that they have now. It takes out a big section. Are we losing anything by taking that section out of defenses that are available?
If I'm not incorrect, Chairman, if I may respond to that, if I'm not incorrect, I think that no municipality can supersede what the state legislature does. Is that correct?
They're not supposed to.
Okay. That being the case, as I understand it, what we were trying to do in going through the total list of code sections in this is to simply make sure that we remove everything that would be an impediment to a non-criminal carrying a firearm on their person. If you would like to make a motion to strike that portion of our bill, then I'm certainly all for that, because I've been working on this, as you well know, for 25 years. And so
No, and thank you for that. I mean, I'm not making that recommendation or even motion. I'm just asking kind of what was the intent there. And so, but I just want to make sure we're understanding what the intent is. I mean, there are sections of 1311. I mean, it's, and again, I support your efforts and the sponsors' efforts to clean this up, because it is very difficult to wade through this for anyone, and it should be simple. And I know that's the goal. I just, at some juncture, either today or at another opportunity, I just want to make sure we look at that very carefully, because we're taking out some offenses, we're taking out some exceptions and defenses. I just want to make sure we don't lose anything in the swap. So just a suggestion, and those are my questions for right now, Mr. Chairman.
Thank you very much. Anyone else? Okay. Thank you very much. Thank you for your time. Next on our list is Toby Meyer. He is not here. All right. Brian Griffin. Not present. Okay. Elizabeth Stroker. You will have, if you will introduce yourself for the record, you will have 4 minutes for testimony.
Elizabeth Stroker, Legislative Director for the Department of Safety, and I don't think I'll take 4 minutes. Sorry, the website is down. There's some slow things, so I'm trying to load everything up here. Wanted to come in and speak today. The Department of Safety is opposed to this legislation because it does a number of things kind of inconsistent with what has already been done in the past in relation to permitless carry. This basically moves it to full permitless carry or constitutional carry within the state without any of the exemptions that this body put into place last year. It would take out the DUI requirements. It would take out the requirements that were added in relation to adjudication for mental illness. It deletes all of the things that you all have decided wouldn't be allowed for permitless carry if somebody were of age. And it also opens it up for anyone of any age. That is a big concern. You could be 14, 12, 16 and be allowed to carry under this and how these laws are changed. And so the department does have a lot of opposition to that, as well as you all know that you can't purchase a firearm until either 18 or 21, depending on what type of firearm that you're requesting or purchasing. So that's where our opposition comes from, is that this body went through and decided what could be qualified for permitless carry within this state, like DUIs, certain stalking offenses, things of that nature. And this would remove all of those, as well as allow for anyone of any age to carry as well without any type of restrictions on that age range.
Thank you. Any questions? Chairman Curcio.
Thank you, Mr. Chairman. So I just want to make sure I heard you correctly. And I'm sure it's not the intent, but the way this has been drafted, a person who's been convicted of stalking could carry a weapon.
That's my understanding of the reading of the bill, yes, or DUI.
Thank you, sir. And a child could, there's no age limit, so.
Yeah, correct. There's no age limit.
Okay, all right. Thank you very much. I just want to make sure I heard that correctly.
You may.
The Department of Safety that you represent, where do you get your authority from?
My authority for what?
Your authority for carrying out the department's laws or whatever. What do you do? What does the Department of Safety do?
Well, the Department of Safety, our mission is to serve, secure, and protect the Tennesseans of Tennessee. My job specifically, I am the legislative director. I am tasked with reading all bills that are filed, determining how they may impact the department, and then conversing with this body on how they would impact the department. I'm also an attorney, a licensed attorney, and I am an attorney for our department as well. So that is within my job function.
So what I'm trying to get at is what gives you or the department the right to come and lobby against any of our bills?
From a procedural standpoint, if we can stay on the bill, please.
Okay. Representative, let's stay on the bill, please.
how am I not on the bill? We've got the Department of Safety here that's coming against my bill. How am I not on the bill?
Leader Lamberth.
Mr. Chairman, this is a member of the executive branch team that is hired by the Department of Safety to come and share information based on that team. That's a procedural issue that we can discuss. There are bills that discuss that. This bill, your bill, and again, support many aspects of it. This is a fact witness that here is to testify about the aspects of this bill and has full authority to do so. This is not a lobbyist. It's not a paid lobbyist. This is an individual that we can gain facts from and can disagree or agree with those, and then we determine the policy. So my objection is that I would prefer we spend the time today actually gaining whatever facts, one way or the other, as you do with Mr. Archie, on this particular bill. That's my objection, Mr. Chairman.
Then why didn't you object when she said she was opposed to this bill?
Go ahead.
Mr. Chairman, and again, we can have this debate. There is a bill out there that sets parameters on these type of employees of the state of Tennessee, but they are allowed to say what, quite frankly, the department's position on a bill is and what the governor's position is. They can convey that information, and then we can either agree or disagree with that, but that's our decision. This is a fact witness that is on a specific bill, and I would prefer, under our rules, at least in the House, that we just talk about the facts of this particular bill. And with all due respect to my friend and fellow representative, this conversation has happened in many committees. This has merely been the instance that I've had an opportunity to address it. I would prefer when we have witnesses that come before us, we ask factual questions of those witnesses and not have a dispute as to whether or not a person that is a Tennessean is allowed to come in and even testify in front of a committee. If they wish to come and testify, I would prefer we ask them questions, gain whatever information we want, and then we make a decision up here on policy.
We're the lawmakers. We make the laws. It's their job to carry out those laws.
Tell you what, we're going to take a brief recess. All right, members, we are back in session, but still out of session. Do we have any other questions for our guest? Representative Sexton.
Mr. Chairman, if it be okay with the committee, what I'd like to do is, with the opposition of safety, I'd like to get a vote on this bill today. And if it goes to full committee, I'd like to ask for the commissioner to come and give us more details about why he's opposed to this bill.
Okay, thank you.
I'll just say I don't know if he's going to be able to come. Our opposition is what it is, and I'm here on his behalf to explain that. More than happy to ask him, but he's got a schedule, and that's unlikely to happen.
I think Representative Sexton will probably make a formal request.
Yes.
For him. Leader Lamberth.
Thank you, and you've done a fantastic job in representing the department here and will continue to do so. We appreciate that. I will say that, anytime that any member asks for a commissioner to appear in front of a committee, we would ask them to take that very seriously, and that is not in any way a reflection on the job that you're doing. You're doing great, but it is, these commissioners do from time to time need to appear before a committee, especially on a very dense bill of this nature, to be able to articulate exactly where they are on different bills. And so I would join in that request at some juncture for the Commissioner of Safety. We'd be happy to move things around. I'm sure we're always accommodating to the different commissioners. They've got big jobs, and I'm personally a fan of this commissioner. He does a great job, but I do think it would be helpful to have him in committee at some juncture.
Thank you. Ms. Stroker.
Yeah, and if that request comes, it'd be great if I could get that sooner rather than later so I can get with him and his assistant.
Any other questions for our guest? Seeing none, thank you. We will go back into session. We're back on House Bill 2524. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none? Oh, Chairman Farmer.
And thank you, Mr. Chairman. I know we spend a lot of time, but I would like to, members, I'd like to make a motion to roll this bill to next week, not take a vote now. I do have more questions. I just don't feel comfortable moving it out of sub at this point in time. I just make a motion if the sponsor we could just roll it to next week, and then we can talk about it, discuss it, and then move it forward. I hate moving a bill forward that I don't completely understand. Yeah. And I think there's a lot of issues here.
There's a motion to roll 1 week. It has been seconded. Any objection? Seeing none, this bill, House Bill 2524, will be rolled to the first of next week's calendar. Also, all remaining bills, well, I'm sorry, we've got time for one more bill. Item number 27, House Bill 2178.
Mr. Chairman, it does have an amendment.
There is an amendment code 14658. You are recognized on the amendment.
Mr. Chairman, if we can, just go ahead and put the amendment on at this time, and then I'll explain.
Question has been called. Any objection? Seeing none, we're now voting to adopt amendment number 14658 on the House Bill 2178. All those in favor say aye. Those opposed, the ayes prevail. You adopt. We are now on House Bill 2178 as amended. There are folks here signed up for testimony.
Question on the bill.
Okay. Leader Lamberth.
Mr. Chairman, those were invited guests of mine to testify. They will not be needed on this particular bill.
We do have one here that Pamela Moses that had requested.
Mr. Chairman, I apologize. That was not a guest that I invited. I believe that was someone who signed up on several different bills. I have no idea whether or not she wants to testify.
Ma'am, do you want to testify on this bill? Yes, sir. We are running low on time, but we will. We have this room for 2 minutes, so I will give you 2 minutes if that's.
That's fine. It seems that y'all rush a lot of things through, and I just wanted to
We're going to go out of session.
Oh.
Okay, you'll have 2 minutes. Identify yourself for the record, please.
Okay, my name is Pamela Moses, and I was kind of shocked from the last bill. I just want y'all to know I've been convicted of stalking. So if you pass that bill, I'll get to carry a gun. But moving forward to this bill, I wanted you to know that I think it violates the right to privacy, and I'm a little confused as to why you want to fly drones in the emergency segment. You know, the TEMA and FEMA, they usually deal with disasters and stuff, and I'm concerned if you pass this bill that you may fly over my house and start collecting data without my permission, as well as the citizens of Tennessee. So I would like for you to please take judicial and legislative notice that the intent of this bill seeks to violate people's right to privacy. That's all. Thank you.
Thank you. Any questions for our guest? Seeing none, we'll go back into session.
Thank you, Mr. Chairman and committee members. Of course, I was concerned about what you just heard in testimony. And to explain that, and I'll read for the record, and where I'm reading off of is the fiscal note. It authorizes the Tennessee Emergency Management Agency to use unmanned aircraft systems to capture images for the emergency management purpose, including surveying the scene of a catastrophe or other damage to determine whether a state of emergency should be declared, coordinating a disaster response, and conducting preliminary damage assessment of real property and infrastructure following a disaster. And of course, we knew what happened in August as far as the flooding and the deaths in Humphreys County, but then shortly thereafter was the tornadoes that hit West Tennessee. Now, the amendment going on, this explains what we can do with those images. Any image collected or obtained by TEMA through the use of a drone for the purpose of damage assessment may be retained by the agency for no longer than 1 year, or if the disaster is declared a major disaster by the President of the United States, for the retention period required by the FEMA, Federal Emergency Management Agency, for data related to damage assessment. All images captured for any other purpose, must be disposed of within 15 business days. Thank you, Mr. Chairman.
Thank you. Any questions for the sponsor? Representative Griffey.
Just briefly, I wish we could get amendments where the public could see our amendments even before we adopt them, and that way it might avoid some misunderstanding about what the bills do and stuff. I just wish we would.
You make the motion, I'll make the second.
Thank you. Representative Hardaway, you have a brief.
Yes, sir. On the issue of how the data is stored and who has access, I think that was part of the concerns of the witness, Pamela Moses. Does your bill speak to that directly, or is that already covered in statute?
Well, part of it is covered in statute because this isn't the first time we've been talking about drones, but here specifically, it's just going to TEMA. They're not sharing it with the rest of the world. I don't know if that helps, but judiciously, of course, when we talk about Humphreys County, the amount of FEMA and TEMA agents, if you want to call them that, came to show up, and it was actually a lot of friends that lost their homes or destroyed their structures, be it the homes or businesses. The agents come up, just walked around, and then left. And part of that, yes, documenting what they're seeing. Of course, a friend said, well, come on inside. You really see the damage if you're on the inside. And they said, no, we can't go there. We can only survey from the outside. So my thoughts with this bill is how faster can we get stuff done than requiring two people to be together at all times, going from house to house to house. And keep in mind, friends, we lost 600 homes. We lost 2 school buildings. We lost every single school bus in the fleet. I mean, and that's an example. How could we expedite the survey of this property, private and public, and then hopefully get the help that's needed in those disaster areas?
Just real quick.
Okay, Representative Beck.
After our tornado here in Nashville, it was too dangerous for them to go in, the down power lines, et cetera, and the drone could easily see what was damaged, and then they can make a plan to go in. So it's an excellent bill. Thank you very much.
Yes, thank you, sir.
Representative Howe. Yes, sir.
Thank you, Mr. Chairman. I just want to thank you for this bill. Recalling the tornadoes in Bradley County in 2011, we had 9 people who lost their lives. Tremendous devastation, tens of millions of dollars in damage. And had we had access to this video surveillance with drones, it would have expedited the cleanup and the dispensation of emergency personnel to the areas that needed it most. There was another situation in a separate incident where I understand that I think it was 11 or 12-year-old boy was out hiking, as boys tend to do,
and got caught in a big mud bog and was couldn't get out. And they used surveillance like this to find him. And they did it in minutes, where if you had 100 people surveying, policing that area, it would have taken hours to do. So I think this is a good bill. I like the parameters that are on it, so I'm glad to vote for it. Thank you, Mr. Chairman.
Thank you, Chairman Howe.
Thank you. Representative Moody.
Real quick, I can top all of you. In West Tennessee, we sit on a major fault line, and if that earthquake, God forbid, ever happens, you won't even have a road to go on. So, I hope we never have to use it for that purpose, but thank you for bringing it.
Chair Lady Moody.
Thank you very much. Any other questions? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 2178 on the full criminal as amended. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move on
Thank
to
you,
full
Chairman
criminal.
Committee.
Members, all bills that were left on the calendar will be rolled to next week's calendar. We are adjourned.